We are following even more breaking news this hour, this time in the legal saga between actors Blake Lively and Justin Baldoni. A federal judge has dismissed Baldoni's $400 million countersuit against Lively and her husband, Ryan Reynolds.
So here's what no one's really talking about. Blake Lively didn't just walk away from that lawsuit clean. She walked away having completely dismantled Justin Baldoni's entire legal strategy. And what's crazy, most of the internet missed it. The headlines made it seem like it was just another Hollywood case tossed out. But this wasn't about technicalities. This was about how Blake Lively, Ryan Reynolds, and her legal team completely outmaneuvered Baldoni's claims with surgical precision. If you thought Baldoni was going to win, you weren't alone. It looked like a slam dunk from the outside. Multiple defendants, explosive accusations, and a public narrative that painted him as the victim of a smear campaign. But once you actually get into the court's 132-page ruling, it becomes clear. The lawsuit didn't collapse by accident. It collapsed because the court found it had no backbone. And here's the thing. This wasn't just about the facts. This was about what wasn't there. Missing contracts, vague threats, assumptions being passed off as proof. We're going to break down exactly what the judge said, why those claims failed, and the one tiny opening that's still left for Baldoni, if he can find a way to crawl through it. Because while public opinion was on his side for a while, the courtroom told a different story. And what that story really showed is that Baldoni wasn't fighting with evidence. He was fighting with emotion. And in court, that gets you nowhere. Let's get into how Blake Lively's team let the paperwork do the talking, and why Justin Baldoni never even had a real shot.
Blake Lively's motion to dismiss and Justin Baldoni's opposition to her motion to dismiss, which he recently filed on April 3rd. In my last video on Lively's motion to dismiss, I talked about the legal privileges that she asserts in her efforts to dismiss his defamation claim. And my takeaway at the end was she's probably not likely to win on every single one of these arguments, but there's enough here to make me think that she could make his defamation claim against her go away.
The judge didn't just throw out Baldoni's claims, he dissected them. Every argument was broken down line by line, and when you see the legal reasoning behind it, you start to realize Baldoni brought a knife to a gunfight. The court made it painfully clear. To survive a motion to dismiss, your allegations have to be specific. You can't just say, "She threatened me," or "They ruined my name." You need hard facts, dates, documents, direct quotes. And Baldoni, he brought almost none of that. His extortion claims, for example, were built around the idea that Lively used her influence to take control of the film, that she refused to promote it or attend the premiere unless she got her version of the movie released. But here's the problem. That's not extortion, that's negotiation. The judge said this wasn't about someone demanding hush money or making unlawful threats. It was about a high-profile actress exercising leverage in a creative dispute. Even worse, Baldoni couldn't prove harm. The court emphasized that to allege extortion, there has to be some sort of damage or loss. But the production company didn't fold. They didn't issue the statement Blake supposedly demanded. They didn't lose money. In fact, the court said flat out, Wayfarer did not give up anything. So right off the bat, the biggest claim in Baldoni's lawsuit didn't just miss the mark. It wasn't even aiming at the right target. And that would become a theme for the rest of the case.
Anytime you write something in a lawsuit, you can never get sued for defamation. And what the court is saying here is that all of the alleged defamatory statements that Lively made came from that filing. There were no other statements outside of that document that allegedly she had said.
If there's one thing that buried Baldoni's case deeper than anything else, it was his reliance on conclusory statements. That's a legal term judges use when someone makes a bold accusation without actually backing it up. And this lawsuit, it was full of them. Let's break it down. Baldoni claimed Blake Lively orchestrated a campaign to push him out, control the narrative, and destroy his reputation. He named Reynolds, Lively's publicist, and even the New York Times as part of a coordinated effort. But what he didn't do was provide evidence of coordination. The judge specifically pointed this out. There were no dates, no messages, no indication of who said what to whom or when. And without that, the court saw it for what it was: speculation dressed up as a lawsuit. One example, Baldoni said Ryan Reynolds screamed at him and demanded an apology. But the court found that this didn't prove Reynolds was acting maliciously or as part of any conspiracy. In fact, the documents actually supported that Reynolds believed Lively's claims, which made his reaction not defamatory, just emotional. Another problem? A lot of the statements Baldoni tried to use as evidence of defamation came directly from Blake's legal filings, and those are protected under something called litigation privilege. In simple terms, if it's said in court documents, you can't be sued for it. So not only were his claims vague, they were legally untouchable. That's the level Blake's team was operating on. They didn't just deny the claims, they showed that the claims had no legal foundation. And once the court saw that, there was no going back.
That civil extortion, the claim was based on one, allegations that Lively refused to return to production unless the Wayfarer parties agreed to her return to production demands. Remember, she said that she was suffering all these problems on set. Two, that Lively threatened to abandon her contractual obligation to promote the film or approve marketing materials unless the Wayfarer parties agreed to co-fund a screening of her version of the film. Three, that Lively threatened to boycott the premiere unless Baldoni was excluded. Four, that Lively and Reynolds threatened to attack Wayfarer in the press if it did not take the blame for problems during filming. And the court says the last set of allegations is not actionable because Wayfarer did not acquiesce in the threat and did not accept blame for problems during filming. And you know what the problem is here? Quote, Wayfarer did not lose anything, and Lively and Reynolds did not gain anything from the threat. And also, quote, the remaining allegations must be dismissed because the allegations regarding Lively's wrongful threats are conclusory and fail to support that the threats were wrongful. Furthermore, the Wayfarer parties have failed to plead that several key instances of alleged extortion caused actual monetary loss. For example, the judge says the Wayfarer parties focus significantly on the demand by Reynolds and Lively that the Wayfarer parties issue a self-destructive statement taking blame for Lively's press woes, or else the gloves would come off and they would attack Wayfarer in the press. However, the Wayfarer parties refused to issue any such statement. Accordingly, there was no reliance on the threat. The Wayfarer parties did not give up anything to Reynolds or Lively, and plaintiff did not sustain damages cognizable in a cause of action for duress.
In court, the word damages is everything. It's not enough to say someone hurt your feelings or made your life harder. You have to prove that their actions cost you something: money, opportunities, reputation that can be measured. And Baldoni, he didn't bring that proof. Let's take the threat to skip the premiere. The lawsuit claimed that Lively said she wouldn't attend unless Baldoni was excluded. But even if that were true, the court asked, was she legally required to be there? Did Baldoni suffer any measurable harm by being sidelined? The answer? No. The court said that even if she had obligations, the requested changes were still directly tied to the production, not outside threats or unrelated blackmail. And more importantly, Wayfarer couldn't show that any of this resulted in financial loss. No missed deals, no drop in box office returns, nothing. Another example? Baldoni claimed that Lively and Reynolds pressured the studio to accept her version of the film. He said it was a power grab. But again, there was no evidence that her version of the film damaged the final product or cost Wayfarer money. And the judge laid it out clearly. There is no disproportionate exchange of value, no nefarious intent, and no financial consequence. This wasn't extortion. It wasn't fraud. It wasn't even unethical by legal standards. It was just a messy creative disagreement dressed up as a legal crisis. At the end of the day, the judge couldn't award damages for things that weren't lost. And without that, there was no case to move forward.
The next aspect of Justin's lawsuit was the defamation aspect, saying that Lively, Ryan Reynolds, and the publicist defamed him. The judge said, based on the facts presented, Ryan and the publicist thought they were true based on the information available to them. So the defamation part got thrown out.
When the headline said Ryan Reynolds screamed at Baldoni, half the internet instantly pegged him as the wild card who would sink Blake's defense. And let's be real, picture Deadpool unloading on a director, and you expect fireworks in court. But passion isn't the same as malice, and that single distinction gutted the claims against Reynolds before they ever saw daylight. The judge's analysis is brutally simple. Defamation against a public figure requires actual malice, legal shorthand for making a statement you either know is false or seriously doubt is true. Baldoni never showed that. All he produced were anecdotes. Reynolds confronting him about how he allegedly treated Blake, Reynolds furious that Baldoni asked a trainer about her weight, Reynolds telling an agent to drop the guy. Are those moments aggressive? Absolutely. But the paper trail showed Reynolds believed the allegations were real. If he thought Baldoni had crossed the line, then repeating that belief, even loudly, doesn't satisfy malice. It's opinion grounded in information he trusted. And about the supposed contract interference with WME. Again, no receipts. The court noted Baldoni never attached an actual WME agreement, never cited emails where Reynolds told agents, cut him loose, never tracked any lost deals. Without proof of an enforceable contract, plus evidence Reynolds knowingly sabotaged it, the claim sits DOA. So instead of being a smoking gun, Reynolds became Exhibit A for why the lawsuit felt hollow. His anger showed he wasn't secretly plotting a smear. He was reacting like a spouse convinced something went down. Emotion isn't illegal, and in this courtroom, intensity without intent is just theatrics.
On Baldoni and parties' claims of defamation, the dismissal notes, Wayfarer parties have not alleged that Lively is responsible for any statements other than the statements in her CRD, or California Civil Rights Department complaint, which are privileged.
Public figure defamation cases are already hard mode. You need a false statement, published, that shreds someone's reputation, plus proof of actual malice. Baldoni tried to vault that bar with 3 pieces of evidence. Blake's civil complaint, Ryan and PR rep Leslie Sloan's alleged whispers to reporters, and the New York Times article that nuked his Google results for weeks. The judge dismantled each one, brick by brick. First, Blake's civil filings. U.S. courts give statements made in pleadings near total immunity under the litigation privilege. The logic is simple. People need to air allegations freely in court. So every explosive paragraph Baldoni waved around, sex harassment accusations, retaliation narratives, was untouchable. He might hate the words, but he can't sue her for writing them. Second, the unsourced leaks. Baldoni's amended complaint hinted that Blake's camp fed the Times juicy insider quotes. But hinting isn't proving. He never produced emails, text chains, or even a named source who heard the plan. In judge speak, that's conclusory, and conclusory equals dismissed. Third, the Times piece itself. Even if the article leaned Blake's way, the newspaper is shielded by the fair report privilege when it cites public documents like lawsuits. Unless Baldoni could point to a factual error the Times knew was wrong, he was swinging at air. Most people missed the final dagger. Baldoni's own timeline contradicted malice. He admitted the defendants believed their harassment narrative long before the article dropped. If they thought it was true, there's no reckless disregard. Result? The entire defamation stack got swept into the trash, leaving Baldoni with headlines but no legal ammo. Early coverage made the alleged shadow PR sabotage sound like a Netflix thriller. Secret teams, late-night strategy calls, reputations destroyed by whisper campaigns. In court, however, it fizzled faster than a cheap smoke bomb. The judge needed 3 things: who orchestrated it, what they specifically said, and how it damaged Baldoni. None showed up. Let's start with coordination. Baldoni's narrative pictured Blake, Reynolds, Sloan, and media contacts moving in lockstep. But he never produced shared talking points, Slack logs, or even a CC'd email chain. Courts treat conspiracies like group projects. If you can't list the participants' individual roles, you didn't do the homework. Next, content. The lawsuit alleged vague, false narratives about sexual misconduct and retaliation, but failed to quote a single defamatory statement made outside the protected lawsuit context. Judges don't chase phantom quotes. They want the exact words. Baldoni had none. Finally, harm. Remember, PR damage has to be quantifiable. Did he lose brand deals, speaking gigs, future directing jobs? The complaint gestured toward reputational loss but supplied 0 financial metrics. Without line item damages, the smear campaign claim is just storytelling. What sealed its fate was the judge's observation that Wayfarer, Baldoni's company, ultimately ignored most alleged threats. They refused to issue the apology Blake supposedly demanded, kept editing the film, and soldiered on. If the PR machine existed, it clearly failed to coerce them, hardly the mark of a devastating conspiracy. So the smear campaign ended up like a Hollywood set, impressive from far away, hollow when you tap the walls. The court poked, the structure echoed, and the entire theory collapsed, leaving nothing but dramatic dust. After wiping out pages of claims, Judge Lyman did leave 2 doors cracked, more out of procedural courtesy than optimism. He granted Baldoni permission to amend. 1. Tortious interference with contract, and 2. Breach of the implied covenant of good faith and fair dealing. Sounds promising, right? Not exactly. Door 1. Tortious interference requires a valid contract, plus proof the defendant intentionally caused a breach, leading to measurable damages. Baldoni says Reynolds told WME to dump him. But unless he can unearth a signed agency agreement, show WME actually ended it because of Reynolds, and put a dollar figure on lost work, the claim dies on resubmission. Rumor won't cut it. He needs receipts, emails, witness testimony, billing cancellations. Door 2. The implied covenant claim hinges on Blake allegedly abusing her consulting rights to hijack creative control. The judge hinted Baldoni might cure this by attaching the star's contract and showing how her edits exceeded reasonable bounds. Trouble is, creative control clauses in Hollywood are famously broad, especially for A-list talent. Unless Baldoni can prove she violated a specific contractual line, the court will likely shrug again. Legal insiders call these courtesy amendments. The judge is basically saying, show me something real or stop wasting docket space. Given Baldoni's first 2 swings missed by a mile, few expect a knockout in round 3. And remember, Blake's team can now file for attorney's fees once substantive claims get dismissed with prejudice. If Baldoni keeps pushing flimsy amendments, he risks not just another loss, but a 7-figure legal tab. Simply put, the door is cracked, but the hallway beyond is booby-trapped. Strip away the glossy headlines, and what remains is a masterclass in how courts separate spectacle from substance. Justin Baldoni framed himself as David against a Hollywood Goliath, but the slingshot he brought was empty. His allegations leaned on public sympathy, vague recollections, and broad theories. Powerful in a podcast, powerless in a pleading. Blake Lively's side, meanwhile, didn't have to grandstand. They let procedural law do the heavy lifting. Litigation privilege, fair report rules, the actual malice standard, and the age-old mantra that contracts speak louder than complaints. At every turn, the judge asked for documentation. At every turn, Baldoni produced narratives instead of numbers. The public assumed his suit was rock solid because it was loud. Yet in the quiet of a federal courtroom, loudness doesn't matter. Specificity does. Extortion without harm, defamation without falsity, interference without a contract. Each claim snapped under its own weight. Could Baldoni salvage something with an amended filing? Maybe, but the odds look worse than opening weekend for a box office bomb. And if he swings again and misses, he may bankroll Blake's attorneys on the way out. So, what's the big takeaway? In Hollywood disputes, control of the storyline often feels like control of the truth. But the law only respects what you can prove. Blake's team understood that from day one. They didn't need trending hashtags, they needed paperwork. And in the end, paperwork won. Quietly, decisively, and with a 132-page mic drop that most people will never read. Next time you see a celebrity lawsuit blow up online, remember, the court isn't grading drama, it's grading receipts. And if this deep dive helped you see the case differently, consider smashing that subscribe button.